is Sally Flashberger with the Wisconsin Board for People with Developmental Disabilities, and it's Living Well Wednesday, so we're here for another great presentation. We're excited because this is Disability Employment Awareness Month, so we're going to hear a little bit about what that means from Shannon, and then Caitlin's going to go through some of the one of our projects at BPDD that focuses on employment, and then we're going to hear from Monica Murphy. She's an attorney with Disability Rights Wisconsin. She's going to talk about employment discrimination, job accommodation, all sorts of good information that you might need going into looking for employment or being employed. So I'm going to turn it over to Shannon. She's going to give us a little history on disability employment.
Yeah. Thanks, Sally. So my name's Shannon Webb, and I'm an independent consultant, but I work on a lot of projects with the BPDD, including Living Well and their employment projects. So I'm happy to be talking about National Disability Employment Awareness Month with all of you. So this year, it's the 75th year of National Disability Employment Awareness Month. That's a mouthful. If you can believe it, back in 1945, Congress passed a law saying that every year in the month of October, we would recognize the importance of workers with disabilities and raise awareness to that. So we, 75 years. And so again, still continuing to try to raise awareness to employment and the importance of employment in people's lives. This year's theme, because every year there's a theme or a tagline to the National Disability Employment Awareness Month campaign. This year's theme is increasing access and opportunity. And every year, the federal government, through the Office of Disability Employment Policy in the Department of Labor, puts out materials, posters, fact sheets, other kinds of press information that organizations, employers, states, can use to promote disability employment. And for the Board for People with Developmental Disabilities, employment has been one of their top priorities in their state plan this last 5 years. And so they have a number of projects that, are aimed to raise awareness and increase employment opportunities for people with disabilities and competitive integrated employment. And it fits with Living Well because we know that, we've heard the stories and we see it in people's lives, and there's research that says that community leads to better health, well-being, and independence for people with disabilities. So it's a good thing for everyone. So all month long, BPDD does stuff, both on social media and different ways to outreach around employment. So Caitlin is going to talk about that. So I'll hand it off to Caitlin.
I'm going to share my screen. I'm going to show you the newsletter that we put out at the beginning of the month. So that was last week, Friday. We sent a newsletter out. We put it on social media. We sent it to legislators. We sent it to providers and all kinds of people. We're going to do that every week this month to highlight the really cool things that BPDD does around employment, championing integrated employment. Is a huge part of what BPDD does through projects and initiatives and in their social media and their advocacy. So this is a really important month for us. We really celebrate the stories of the people who are working in community integrated jobs. And so let me go ahead and show you what that newsletter looks like. Give me 1 second. There it is. All right, can you see that? Yeah? Okay.
Yep.
So this is the newsletter that we put out last week. We're gonna, like I said, we'll send out one every week on Friday celebrating what's going on. We talk a little bit about the history of National Disability Employment Awareness Month and its long history. We highlighted here our disability employment rights. So people with disabilities have employment rights. That is true all the time, but it's in particular, we're focusing on what you still have while COVID is going on. So we have our employment rights section of the Living Well Toolkit on the newsletter this week for you to see. Both of these links on here, all the links are active, but both of the links on the front page that say register now in Zoom link give you the option to register for all of the Living Well Wednesdays that are coming up this month that are going to have a disability focus. So if you are free this time every week, you can join us either on Zoom or Facebook Live, and the links are available. We'll post them, but they're also available here in the newsletter. And then the second page talks a little bit about two of our employment initiatives at BPDD. We'll talk about some other ones as we move through the month. This is Take Your Legislator to Work and the Employment First conference that happened in May. So I'm going to get a little bit more into Take Your Legislator to Work in just a minute, but the Employment First conference was held virtually this year in May, and it offered a great variety of sessions about policy and direct service and all kinds of stuff, and those sessions were recorded. The plenary and keynote and specifically are great recordings if you're interested in hearing what went on, and we already have a date for next year. So May 13th, 2021 will be the date for the Employment First conference next year. If you want to put that on your calendar now, it's a really great opportunity to learn more about what the Employment First legislation does and all the work that goes around Wisconsin's Employment First. We also have a link to the Self-Determination channel on YouTube, which has lots of great videos of people who are working. We have a video celebrating people who are essential workers and all of the great work that they do. So it is a great resource, and I'll go ahead and put the link to this in the chat as soon as I get a chance. And then I'll put it on the comments on Facebook as well. So like I said, I would talk a little bit more about Take Your Legislator to Work, which is our initiative that connects people working in the community with their legislators. And we have a really great video that I want to show. It's from a couple years ago. It's from when we were doing these Take Your Legislator to Work visits in person. So I'll talk a little bit more about how it's changed right now during COVID, but it's still a really great video that I wanted to give you the opportunity to see because I think it really highlights what the program does in a really good way. So give me 1 second to switch screens and we will get started. Okay.
Hi, my name is Jennifer Court. I am the president of People First Wisconsin. I work at Piggly Wiggly and have participated in the Take Your Legislator to Work campaign for 5 years. It's a great way to show my legislator what I do at work and how I contribute to my community. Here is how it works. First, request a Get Started kit. Inside is a letter to show your boss. If you get the okay, fill out the application and send it in. After your application is accepted, you will receive a participant packet with everything you'll need. Now it's your turn to invite your legislator to work. Nathan and Ivan are going to help me show you how easy it is to host a visit. Nathan works at Henderson's Landscaping. Ivan works at the Marquette University Rec Center. Nathan and Ivan invited both of their legislators. Let's tag along.
Hey, Ivan. What's up?
Every visit starts with introductions. Greet your legislator and introduce your coworkers and boss. Bring the stickers and buttons from their participant packet. Have your legislator choose one to wear. Be sure you're wearing your Take Your Legislator to Work t-shirt. Next, give a tour. Ivan showed how he signs in for work and gathers his materials. He showed the accommodation that helps him do his job. Ask your boss to talk about the good work that you do.
Ivan is known as the human Zamboni. Nobody cleans floors like this guy. We're averaging close to 1,500 to 2,000 people users per day. Our courts get very, very dirty. So it's great to have Ivan come in to get the courts cleaned up. If that wasn't done by the end of the night, it's an unsafe, floor to play on. He's a real asset to our program.
You have to tell Nathan to take breaks because he just keeps motoring along.
It's just a great attitude. Every day he comes to work, he's got a smile on his face, and it's on there all day long.
I talk to a lot of business owners who can't find employees that have that work ethic. So when you find somebody like Nathan who loves to work and is not afraid to work, that's important.
It is. It is.
This visit is your chance to talk about issues that are important to you. It is also a chance to get to know one another.
I probably have 2,000 bobbleheads. Yep, I collected them. I went to baseball games with my dad. We bobblehead collectors got to stick together.
Yeah. A typical visit usually takes 30 minutes to 1 hour. Sometimes the local news station or paper shows up to cover the event.
If you work, you get money, and money you can spend on special stuff, or like a car or anything you want.
You can also invite family and friends who support you. You can even invite your legislator to try out your job. Every visit is different. That's what makes the Take Your Legislator to Work campaign so unique and special for you and for your legislator.
I think it's very important for legislators to take you up on this opportunity to come and visit and learn and see the great work that people with disabilities do at their day job. I jumped at the opportunity so I can learn a little bit more of the things that Ivan does day to day and to see what he brings to the Marquette University community.
Now your legislator knows you. You can call anytime and share your ideas. Be sure to follow up with a thank you note and a photo. Photos make great memories, so take lots. After your visit, you'll receive a certificate, one for you, for your employer, and for your legislator, thanking you for being part of the Take Your Legislator to Work campaign. Now it's your turn. Share your story. Take your legislator to work.
All right. So that is a really good overview of what Take Your Legislator to Work does, what we've done in the past with it, and what an impact it can make in building advocacy skills for people who are working and sharing really important employment stories with legislators. Unfortunately, because of COVID, we've had to take a pause on doing those visits in person. So a little bit of what we do now has changed. We're encouraging people to still connect with their legislators, still to take them to work, but to do it right now in a virtual way so that everybody's health and safety is protected. What that means is having a visit virtually, so it could be live over Zoom, where you get to show your legislator your job and do a lot of the same things that would be happening in a live visit, but just virtually over Zoom. If that's not really an option that works for your place of employment or for your schedule, then pre-recording a tour of your place of employment is another option that we can help you facilitate, or even just doing a written story about with pictures about your job and about the things that are important to you in your job. All of those are options still. That way people can connect with their legislators, let them know that they're working, let them know what's going on and the things that are important to them regarding their community employment. I'm going to show you our virtual application so that you get a little bit more of a sense of what things have changed and what we can do to help facilitate that opportunity for you. So one more share screen for you. There we go. Okay. So Take Your Legislator to Work virtually. This is the participant packet. It's another link that I will put in the chat and in the comments on the Facebook page if you're interested in seeing this. This is what the first thing that, if you send me an email or you reach out and let us know that you're interested in doing a Take Your Legislator to Work visit virtually, this is what I'll send you. It has a Get Started kit, which talks about ways that you can connect with your legislator virtually, and a fillable form of step-by-step things to do to get your visit ready to go. So what you're going to want to do first is get it approved with your employer, or if you're the employer, you know, and you've identified somebody that you think would like to do this and have this opportunity, then talking to them and making sure it's something that they're comfortable with, and making sure it's something that they feel ready to lead on, because we think it's important that they take the lead. Or if you're a legislator and you're really interested in doing this with us, you can send me an email, reach out, and we can try and find somebody in your district who is working in the community and who would love to show you around their place of employment. We'll handle it any way you come at us. We will make sure that you get connected. But if you are an employee and you are interested in doing Take Your Legislator work, the first thing you're going to do is give your employer a letter that explains what's going on, and have a conversation with them about what Take Your Legislator to work is, and make sure that you guys are on board for what it will involve. That way, this process can move really smoothly with everybody on the same page. Then you're going to fill out the participant application form and send that back to me. It's got the address on there to my office. You can send it there. It's going to take a little bit longer for it to get to me because I'm not working in the office right now. So the best way to get it to me is through my email. But if you send it in a paper version, we'll make sure that it gets to me. So either way is fine. And once I get your application, I will get in contact with you, and we will figure out what it is that you're going to need from us to make your visit successful. And that might be me hosting the Zoom between you and your legislator so that I can handle all the tech for you. It might be me helping you figure out how to record a visit in your place of employment and then putting that video together for your legislator. Or it might be you sending me quotes and pictures so that we can put a little blurb together and send it in a written form to your legislator. I'm happy to help with any version that works for you. The employment letter is included, the employer letter is included in here. It gives them a little bit more information about what a virtual visit would entail, and has my contact information, so if they need to ask me some more questions, then they can absolutely reach out and do that, and we can make sure that your employer knows everything that they need to know to have a successful visit. And then the participant application has just some really basic questions about where you live. That way I can make sure that the information I send you about your legislator is up to date and correct. You can have a visit with the legislator who represents you in the assembly or in the Senate from where you live, but also sometimes it might be easier to connect with the person for the assembly or Senate district that is where you work, if that might be in a different district than where you live. So there's lots of options to get you connected with somebody, and we can dive into all of those. We want to know if you've gotten permission from your employer to do this program. That helps us facilitate it easier and make sure that there's no miscommunication. We don't want to, set something up and then have it be that it doesn't work out in everybody's schedule. So that's important. And then there's a place if you're going to have somebody, a supporter, help you work through the applications and work through the visit. You can put their information there. And then a little bit more about your job, how you, when you work, how you get to work, if you were working during the pandemic, what you like about your job, all those kinds of things. And then what way you would prefer to have your visit. And this can change. You can put your preferred method down for right now. And as we talk about it, if a different one seems like a better option, you can change that. It's just so that I have an idea of what would work best for you. So that's the application. You'd fill that out, send it to me in an email, send it to me in my office, and then I will get in contact with you. I'll make sure that you get everything that you need to have your visit virtually, and then I can be there every step of the way to help, or I can just be a sounding board for questions, and you can, people can handle it on their own as well. My involvement is really dependent on how much people need. And we can move the process forward. As soon as it is safe to do in-person visits again, we will let everybody know. That doesn't mean necessarily that virtual visits can't be a thing that you choose to do if that's still the best option for you. But when we can have in-person visits, then it'll be a lot more like what you saw in the video, and we can do them that way instead. So I think that's all the information I wanted to share. I'm going to pause and answer any questions that people have about this, and then we'll hand it over to Monica to talk about employment rights, which is another important part of what we're highlighting this month and, for National Disability Employment Awareness Month.
So there's no questions in the chat, except I do see someone raise their hand who's on the phone. So I'm gonna, that person would need to unmute to ask their question. So if you raised your hand, do you want to try to unmute and ask your question? Yeah, I'm not sure. All right, well, we'll see if that person can maybe figure out how to unmute and go from there on the phone. It's a 715 number. But just important information, I think we definitely know people with disabilities are still working, and we have a lot of people who maybe are considered essential, where they might work at a grocery store or places that really are providing services during the pandemic regardless. It might be interesting too if we have any people who are actually working virtually for legislators to be able to see just how people are working during the pandemic. So great information. All right, I'm gonna turn it over to Monica. Monica Murphy is an attorney with Disability Rights Wisconsin. She's been with us before.
This is Ramsey. I was the one that raised my hand. Can you guys hear me?
Yeah, we can hear you, Ramsey.
Oh, thanks for having this. I was wondering, that video you just showed, is there a link to it on some type of website so people can access it later?
Yeah, absolutely. So that's a good point, Ramsey. Thank you. I will put the link to the YouTube video in the chat and on Facebook, but I also will put the link to our website because it is on our Take Your Legislator to Work page on our website. So I'll include the link to that page on our website as well, because there's some good resources and this application is up there as well.
Okay.
So you can get it through the Facebook page because you won't be able to see it on the chat in our Zoom because you're on the phone. So
I apologize. I didn't catch who was talking. I think I hear Sally Strasburger. And who's the other one that's talking?
Oh, hi, Ramsey. This is Caitlin McNamara. I do the Take Your Legislator to Work program with BPDD.
Oh, thanks for what you do.
All right, thanks, Ramsey. I think we're gonna move on to Monica. I'm just going to, perfect, you're muted. Okay, so we have Monica Murphy with us. She is an attorney with Disability Rights Wisconsin, and she specializes in employment law. And so she's gonna talk us through the protections for people with disabilities. And I'm gonna share my screen so I can get her PowerPoint up. Just give me 1 second. All right, can you guys see that? Yep, can you see it?
Yep.
Okay, great. Take it away, Monica.
Okay, so I'm going to talk to you today a little bit about protections you have under the law from disability discrimination in the workplace. And there's two main laws I'm going to talk about. One is the federal law, the Americans with Disabilities Act, and one is the state law that we have here in Wisconsin called the Wisconsin Fair Employment Act. The ADA the Americans with Disabilities Act, Title I of the ADA covers employment, and it applies to all employers of 15 or more employees. So to be covered under the ADA, you have to be working for an employer that has at least 15 employees. The law requires reasonable accommodations. It prohibits discrimination on the basis of disability, and it's enforced through the Equal Employment Opportunity Commission, and we'll come back to that a little bit later. Next. So under the ADA, to be protected under the ADA, you have to meet the definition of a person with a disability. And a person with a disability is somebody who has a physical or mental impairment that substantially limits one or more of the major life activities, or has a record of such an impairment. So if you had a disabling condition and you've recovered from it, you know, perhaps with cancer or sometimes significant mental illnesses you can recover from, but you can't be discriminated against because you have that in your past. And sometimes people don't actually have conditions that meet the level of being substantially limited, but other people view them as if they do. So it also prohibits you from being discriminated against because someone thinks you have a disability. Next. So to be protected under the ADA, you have to be a person with a disability, but for the employment provisions, you have to be able to do the job in question with or without reasonable accommodations. And we'll talk a little bit more about what reasonable accommodations are, but you have to meet the requirements of the job. In other words, you have to be able to, if there's some particular education that you have to have for the job, or if there's some certain skills you have to be able to do to qualify for that job, you still have to meet those qualifications. Now, that may be, you may be able to meet them with accommodations, but you have to be able to do the job and with the skills that are required for the job. So the ADA prohibits discrimination in employment. It applies all across the lifespan of a job. Even before you get a job, it can apply in the application process. Employers can't make their job applications inaccessible to people with disabilities. They can't ask questions about your disability on an application. If you need accommodations to participate in an interview or to fill out an application, an employer has to provide those. So it can start way even before you're hired by somebody. And it applies to the interview process, and it applies to getting hired. And then, you know, throughout your employment, can't treat you differently than non-disabled employees. They can't give you different benefits or pay you differently than non-disabled employees doing the same work. So you have to be treated fairly throughout the whole employment process. The key aspect to both the Americans with Disabilities Act and the Wisconsin Fair Employment Act in terms of the protections it provides is the provision for reasonable accommodations. Most discrimination laws like sex discrimination or race discrimination protections don't have a requirement for reasonable accommodation. That's something that's different for disability law. Next. So what is a reasonable accommodation? A reasonable accommodation can be changes to the environment in which you do the job. We often think of this specifically for people who have physical disabilities, and there has to be some physical modification to the environment to make it accessible for them. But it certainly could apply in other conditions as well. Sometimes it's changing the way in which the tasks of the job are done, or the order in which they're done. Sometimes it means adapting equipment or providing adaptive equipment to help people do the job or use, you know, tools that are accessible to them. And sometimes it means restructuring the job, changing the work schedules. Maybe you're not able to work 40 hours a week. Maybe you can only work 20 hours a week. So maybe there's a modification of the work schedules. Maybe it's because some medications you take, you can't function very early in the morning. So rather than starting at 7 in the morning, you start at 9 in the morning, that sort of thing. So there can be different things that are accommodations that make it possible for somebody with a disability to have equal opportunity to perform the job. Next. So what should you do if you think you need an accommodation? As I said, the accommodation requirement can apply even before you're hired. So if you need an accommodation to apply for a job, you should contact the employer and explain your need. If you are already employed and you are on the job and you realize you're struggling with some aspect of the job, you can ask your supervisor for an accommodation. Now, you don't have to use any special language. You can just say, you know, I'm struggling with this because of my disability. What can we do? You don't have to disclose a disability before you're hired. You don't ever have to disclose a disability if you don't need any accommodations for it. But if you get to the point where you do need a reasonable accommodation, you have to disclose your disability, because the employer is not obligated to provide an accommodation unless you are disabled. There's not a limit on the number of accommodations you ask for. Your boss can't say, well, we already provided you with X accommodation, so we don't have to do anything more than that. There is no time frame that you are limited to asking for an accommodations. So for example, if you get a new job and you're working on the job and you realize you're going to need an accommodation, the employer can't say to you, well, you didn't tell us that, you know, when we hired you that you needed an accommodation, so we're not going to provide an accommodation. It doesn't work that way. The employer can be required to provide an accommodation at any point in the employment relationship. And oftentimes the accommodations you need may vary over time. Maybe there have been changes to your disability. You've had some operations, or there's other things that have happened with your disability over time, or maybe your job duties have changed over time. And so the things that you need to be able to do on the job have changed, and you need some different accommodations. So it's not a one and done thing, and it's not, you aren't trapped in any time frame in which you have to ask for the accommodation. Next slide, please. So when you ask for an accommodation, unless it's very obvious what the disability is and what the need is, the employer is supposed to engage with you in what's called the interactive process. And the interactive process is really just an opportunity to try and figure out what limitations or that you experience because of your disability, or what abilities you have that can be relied upon to do the job duties, what tasks need to be done, what the employer needs to have you do, and you're to work together to try and figure out what might be an appropriate accommodation. Maybe you have some ideas. You've been living with your disability and you know what works for you. Maybe the employer has some ideas because they know the tasks that have to be done. And it's really an opportunity for you to work together to try and identify the appropriate accommodation. But if the employer refuses to engage with you on what might be an appropriate accommodation, or if the employer asks you questions about your disability or what you need and you refuse to respond to that, either way, that can break down the interactive process, and that can limit what the ADA is able to provide for you in terms of reasonable accommodations. It would be a violation of the ADA if the employer refused to discuss accommodations with you and refuses to consider accommodations. Next slide. So maybe you have some ideas about what might be an appropriate accommodation for you. You have saw some piece of technology that you think would be helpful, or you think that having a full-time job coach might be helpful. An employer doesn't necessarily have to give you the accommodation that you ask for. What an employer has to do is provide an accommodation that is effective. So if the accommodation that the employer offers, even if it's not the one you particularly asked for, if it is effective and will allow you to have equal opportunity to do your job, then the employer has met their obligations to provide an accommodation. And again, this is something that should be looked at over time. If you are provided with an accommodation, you need to do check-ins and see if it's working. If it's not working, then you need to tell your employer that you need to look at some other accommodations. It's an ongoing process. It doesn't have to be, you get your one shot at it and that's it. So again, the whole accommodation relationship can vary and change over time. Next slide. Okay. So a question that often comes up is who pays for an accommodation? Usually it's at the expense of the employer, but it's important to know that a lot of accommodations don't have any cost to them whatsoever. They're just a change in the way of doing things, or a change in the environment that they're done in, or a modification of the rules or the practices of how things are done, and they don't really have any expense to them at all. But if there is a piece of equipment that needs to be provided or that sort of thing, generally it's the obligation of the employer. The employer doesn't have to pay for things that are personal to you, like eyeglasses or hearing aids, things that you would use outside of work. You can provide your own accommodation if you want. And there may also be other sources to help cover the costs. The Division of Vocational Rehabilitation may help pay for accommodations to make your workplace accessible to you, or you may be able to get some assistance from your long-term care programs to help cover. So if you're in family care or IRAS, there may be some ability to get those programs to help cover the costs of accommodations. Next slide, please. So I never do a presentation about reasonable accommodations without mentioning this excellent resource called the Job Accommodations Network. And the Job Accommodations Network is a government-sponsored website that has all kinds of information about what kinds of accommodations may be appropriate for what type of disability. It also has lots of information about what the law requires in terms of accommodations. It has a sample letter you could use to ask for a reasonable accommodation. And it has excellent resources for finding particular accommodations. It's not the easiest job or website to navigate, but it does have lots of information about accommodating various disabilities, what kind of limitations you might expect with that disability, and ways to address those limitations. The other great thing about the Job Accommodation Network is if you look on their website and you can't find the information that you're looking for, you or your employer could give them a call. They have a number that you can call and explain to the person that is providing the assistance what the job is, what's the task that needs to be done, and how the disability is impacting that. And they can give you suggestions, and if they're really puzzled, they will take your information and do some research to try and find the appropriate accommodations for you. And best of all, it's all free, and employers can use it, employees can use it. So I always encourage people to visit askjan.org and get familiar with the various resources there that can help you if you have any kind of employment issues. Next slide. So The next couple slides just talk about what kind of accommodations someone with an intellectual disability might need on the job. And this is kind of how the Job Accommodation Network sets up their accommodation ideas. They look at, so what kind of limitation is the person experiencing on the job, and what are some ways to help with that? So if somebody can't read very well, how can you help them on the job? Maybe you provide them with pictures of things or diagrams. If somebody can't write very well, maybe you provide them with voice-activated software on the computer so they could just speak into the computer to get things written down. Maybe you have somebody who helps write down information for them. So lots of different ways of addressing those particular limitations. Next slide. Some other things that might be helpful for someone with an intellectual disability. Give people checklists, break things down into smaller tasks, label things, color code items. There's really just a variety of ways that you can address certain issues. And there's not necessarily one answer for any kind of limitation. But there's lots of different things you can try, and you can figure out what works best for you and what helps you be able to do your job better. Next slide. Sometimes people with disabilities have communication disabilities, and so that often requires the people around them to be a little more conscious of how they are reacting to that individual. Give that person the opportunity to actually speak and not try and put words in their mouth, not try to anticipate what they're saying. Don't assume you understand if you don't. And try and keep things simple. Try not to use a lot of complicated language, and make communication as easy for everybody as possible. So what if your employer says, well, I can't provide that accommodation you've asked for. It's too expensive. Or we can't do that because that's going to disrupt our work environment. So an employer doesn't have to provide every possible accommodation. And an employer can raise as a reason why they won't provide an accommodation that it's an undue hardship on them. So it may be undue hardship for an employer to provide a particular accommodation. One that I often, and an undue hardship is something that is either very difficult to implement or it has a significant expense. And when you're trying to determine if something is too expensive, you have to look at the cost of the accommodation, what the resources of the employer are. You know, a big employer has a lot more resources than a small mom and pop family business kind of thing. So part of it depends on what might be too expensive for a neighborhood family business might not be a problem for General Motors. So it really depends on the resources of the business and what they can and can't afford to pay for. Or it may be that what's you're asking for as an accommodation would change or disrupt the way the work is done, and it may have too big of an impact on the employer's operation for it to be required as an accommodation. So if it changes the way the business operates, or it has a disruptive impact on other employees, it would be viewed as a fundamental alteration that an employer would not need to provide. So generally there's a requirement to provide reasonable accommodations, but that can be limited if the accommodation is either an undue hardship, costs too much, or it's a fundamental alteration. It changes the way the employer does business. Next slide. And then there is still another defense that an employer might have regarding a person with disability. An employer can refuse to hire someone or keep in employment somebody who poses a direct threat to themselves or others. So if somebody's has very dangerous behaviors in the workplace, or there's some vulnerability that they have that would make the work that they're applying to do particularly dangerous for them, an employer can refuse to hire them. But it has to be something that's based on a real significant risk of substantial harm to either the employee or to other people. It can't be based on some myth or stereotype that, oh, everybody with this disability is dangerous because. It must be decided on a case-by-case basis. And even if an employer thinks an employee would be dangerous to themselves or others in a position, they then have to take another step and look to see if there are possible accommodations or modifications that would limit the dangerousness. So if they think that a particular person can't do some aspect of a job because of their disability, say, because of their disability, they have balance problems in the job, sometimes has people climbing ladders, and you wouldn't want that person to fall off the ladder. So the employer can't just stop at, well, we can't hire that person for the job because we might need them to climb a ladder. The employer needs to look, is there some way we can provide a reasonable accommodation that would limit the risk associated with that person climbing a ladder? Maybe it's not have them do that aspect of the job and have somebody else do it, or maybe it's move the equipment or the items that the person needs so they don't have to climb a ladder to get them. Maybe it's providing some kind of lift that would be safe to get them to the items. There's various ways things like that can be accommodated, but you need to address, to see if there's any accommodations before you determine that somebody would be a direct threat in the workplace. So I mentioned at the start that we have in Wisconsin to be protected by both the federal law, the Americans with Disabilities Act, and the state law, the Wisconsin Fair Employment Act. And I also mentioned that the Americans with Disabilities Act only applies to employers of 15 or more employees. But luckily here in Wisconsin, we have the Wisconsin Fair Employment Act, and that applies to all employers, regardless of the number of employees they have. So even if you work for a small employer that doesn't meet the ADA standards, you still would be protected from discrimination under the Wisconsin Fair Employment Act because it covers all employers. One of the other ways it's different is that there's a little more requirements. They both the ADA and the Wisconsin Fair Employment Act require reasonable accommodations, but the Wisconsin Fair Employment Act has been more broadly interpreted by our courts to require some additional accommodations that wouldn't necessarily be required under the Americans with Disabilities Act. So we have protections about restructuring jobs and modifying job duties in a way that the ADA wouldn't necessarily require. The Wisconsin Fair Employment Act also has been interpreted to require employers to forego disciplining someone or forego writing somebody up or questioning their work abilities if the individual is in a position where they're trying to deal with issues related to their disability. So for example, the lead case on this is a woman who kept falling asleep at her job. Her job was to count money at the Target offices, and she would keep falling asleep at her job, and so she was being disciplined for that. And she went to her doctor, and her doctor said, you know, it seems like you have narcolepsy, you're falling asleep, let's try these various medications. So she went back to work, and the employer said, well, are there any accommodations you need? And she said, well, no, I'm working with my doctor. Well, then she fell asleep again and the employer fired her. And the court said, because she was working with her doctor and trying to overcome the problems associated with her disability, the employer should have, held back a little bit and gave an opportunity for those medications to work, or for her and her doctor to find the appropriate medication that would limit the impact of her disability. So, yeah, that's okay, go ahead. So, as I mentioned, under the Wisconsin Fair Employment Act, the duty to accommodate might be broader than under the ADA. And I kind of sort of already went through these, so we can move on to the next slide. So if you want to raise a complaint under the Americans with Disabilities Act, those complaints get filed with the Equal Employment Opportunity Commission, and that's a federal agency. If you want to file a complaint under Wisconsin Fair Employment Act, those complaints get filed with the state of Wisconsin Equal Rights Division. Under both laws, you have a somewhat limited time to file a complaint. If you were in some other state, you might be limited to 180 days. The Americans with Disabilities Act say you have to file a complaint in 180 days, or about 6 months. But it says if there's a similar state law that gives you 300 days, you can have 300 days to file with the EEOC. And that's what we have here in Wisconsin. So the Wisconsin Fair Employment Act provides for 300 days. So that 300 days is then applied to the federal law as well. But you have to file within 300 days of the discriminatory event. And sometimes that can go by pretty fast. So you need to be conscious of that. The two agencies, the State Equal Rights Division and the EEOC, have a work sharing agreement, so that when you file with one, your complaint is automatically cross-filed with the other one, so that your protections on under both statutes are kicked in, and you don't have to worry about the timelines for the other statute. The EEOC, they both start out somewhat similar in terms of doing an investigation, and they both will share your complaint with the employer. The employer will be given an opportunity to respond. You will probably be given an opportunity to respond to to the employer's response. And then they issue what's called an initial determination. And at that initial determination, they're trying to decide if there seems like there might be some discrimination involved. It's not a final decision whether there's discrimination, but they're trying to decide whether this case warrants looking at further. So if you're with the EEOC, after that initial determination or probable cause stage, you are likely to get a right to sue letter, which says then you can go file your case in federal court if you want. If you're at the Equal Rights Division, when you get past that initial determination, you will, if the decision's in your favor, you will then move on to an administrative hearing process. If they don't think there's probable cause to believe you were discriminated against, you can appeal that decision. And again, you would go to an administrative hearing, but what you would be looking at is whether you'd be appealing that probable cause decision as opposed to the underlying discrimination. Next slide. Okay, so what can you get in a discrimination case? Well, if you lost your job because the employer discriminated you on the basis of disability, you can get reinstated to your position, and you can get back pay for the time that you were off work. If you had out-of-pocket expenses during that time, whether they were job hunting expenses looking for another job, or because you had to pay medical bills that you wouldn't have had to pay had you been able to stay on the employer's insurance. You can get reimbursement for that. And you can get your attorney's fees covered if you have an attorney representing you, if you're successful in these cases. Now, one area where the federal law is more favorable than the state law is the potential for damages. Under the Americans with Disabilities Act, you can get compensatory damages. And those are damages for pain and suffering, or for having your rights violated. That's not available under the Wisconsin Fair Employment Act. Also under the ADA, you could get punitive damages. And punitive damages aren't really about what you suffered, but they're about trying to change the employer's behavior. So if the employer's behavior was pretty outrageous, or they've had problems in the past with similar kinds of complaints, you might be able to get punitive damages. That's not available under the Wisconsin law either. So I'm just going to stop there. That was a pretty quick run through. But if anybody has any questions, why don't you share them now, and I can do my best to try and answer them.
I just have a couple questions that I know people often want to know. So when people are applying for a job, when is the best time to disclose a disability? I think people are always worried about, is there a right time, or, maybe what is your thought process on that?
Well, it's highly individualized in terms of how people are comfortable, what people are comfortable with. You aren't required to ever disclose a disability, as I think I mentioned, unless you need an accommodation. You're not entitled to an accommodation unless you have a qualifying disability, and so you may have to disclose your disability at that point. On the other hand, sometimes, your disability is obvious. You walk into an interview and it's obvious you have a disability. You roll into an interview in a wheelchair, your disability is obvious. So your disability is disclosed. So, but even if it's obvious that you have a disability, an employer, before they've hired you, can't be asking questions about what accommodations you need, or what is your disability, or what happened to you, why are you in that wheelchair, that sort of thing. But what an employer can ask about is, how would you do this job? Here's what's required in the job. How would you do that? And that's okay for an employer to ask about, and you should be prepared to answer those questions.
Right. So it may be not specific to disability, but you may have to answer it along that line.
Right.
I think the other, full disclosure, Monica and I worked together for many years. So one of the other things is, so often, Monica worked for disability rights, people will call in to get help. And so often people have not necessarily disclosed they had a disability, and then they're getting, something's happened at their job, they're in trouble, so what is your advice for people on, making sure they're protecting themselves all along?
Well, certainly if, and it requires some self-awareness, but if you feel like you're struggling in your job, and you think it's because of your disability, I think it's good to open up that dialogue with your employer and look and see if there's possible accommodations. The thing is, if an employer doesn't know about a disability, they don't have to accommodate it, and they don't have to accommodate it retroactively. So if you are in a performance improvement plan, or you've been disciplined for things that have happened and you think it's related to your disability, but you haven't told the employer that, or you haven't asked for accommodations, and then you go into a meeting where this is happening and you say, well, but I have this disability, the employer can still discipline you or can still go ahead with the corrective action plan, but they also at that point have to look into whether there's accommodations that can be put in place prospectively. But they don't have to look back and change what's already happened because you didn't disclose your disability.
And then we're just about at noon, so I'm gonna kind of wrap it up. Disability Rights does, you can call and do an intake with them if you have questions about a situation at your employer. You know, it'll go to somebody who has knowledge, maybe Monica, maybe another attorney or advocate. So thank you so much, Monica, for joining us. We always appreciate your input. We will be here every Wednesday, pretty much. So next week we'll continue discussing employment, looking at different areas. And so look for our Zoom link for that. And then also we'll be on Facebook Live. So we appreciate everyone joining us. And I think we're going to wrap it up. So let me just